Ruby Barr with Southside Community Law Center. There are a lot of people that want to handle their own legal affairs, and that's fine. There is a process in which if a person wants to represent themselves, that is known as pro se. It means that you are representing yourself. A lot of times, someone is going through a divorce, or someone wants child support, or they want time sharing, or what they call visitation or custody. They will fill out these forms. And so many of the clerks in the state of Florida, they have prepared packets with all of the various forms that you need in order to complete to get into court. It means actually file the case in court. And it just stops right there. And so we want to go ahead and want to talk about what it means to, or to assist you in filling out the forms, getting them to court, and briefly share the process and what's next. So now I'm going to be referring to the forms that's in the packet here in the Leon County Clerk of Court. It's on their website. Now, the several of the clerk offices around the state of Florida, they sell these packets. Some sell them for almost $100. I think Leon County probably sells theirs for less than $20, and that's a really good deal because with instructions, it's like 70 something pages, 80 something pages. But now another thing that's important to know, and this is a time saver and it's more economical. You can go to the website, floridacourts.org. That's FLCOURTS.org. And you can pull up the forms. Now it won't be in a packet form, so you actually have to know which form. But it's in categories, so that helps. You can type on them, and then you can print out just the forms that you need instead of printing out the instructions, because there are some forms that it's 8 pages and 5 of them are instructions, and you don't need it, and you don't file that, just the actual forms itself. All right, so now we're going to say you're going through a divorce and you want to know, okay, what is it that I need to fill out? You can go onto the Leon County Clerk of Court and you can get the packet. Dissolution of marriage with children, dissolution of marriage with no children, no property, or simplified dissolution of marriage. Now that's the official term for divorce, dissolution of marriage. Now, simplified dissolution of marriage, that's a legal term. It doesn't mean that it's simple. This is what it means. It means that both parties are signing the documents, and before COVID, both parties would actually go into the courthouse at the same time and submit the documentation there, and they would then shortly thereafter get a court date. The other thing with simplified dissolution of marriage is that you cannot have children under 18. So if you have children under 18 from your spouse, okay, not an outside child, but if you got kids under 18 from your spouse, you can't use the simplified dissolution of marriage. And then if you have assets or liabilities and debts, you have to, liabilities and assets. Liabilities, which is debts, assets, which is property. You have to already be in a complete agreement. Now you can share your agreement with the court or not. You can say it's secret, and that's fine. Now, when we talk about divorce in Florida, before we continue further with the forms, Florida is a no-fault divorce state. That means you do not need grounds to divorce your husband or wife. You don't want to be married anymore, you can say, like, hey, that's it, man, I'm going to get a divorce. It's just that simple, except you have to have lived in the state of Florida for at least 6 months before you file that divorce. And there are sticklers for that. The other thing is that you have to state in the paperwork that the marriage is irretrievably broken. That's all that's required. Someone approached me about a divorce, and they lived in Florida, and then they moved, and then they came back. And so there was an interruption, and so you have to start all over again because, again, you have to have lived here for 6 months. So let's go through the forms. Going through divorce, first form is the petition for dissolution of marriage. Now, when you look at these forms, it's at the top of all forms that go to court, whether it's divorce or a car accident or some other kind of lawsuit. The top part of the first page of any lawsuit or legal petition or complaint, at the top it's always known as the style of the case. That lets us know what judicial circuit the case is in, what county the case is in. And if it's a brand new case, there will be no case number. But if it's an existing case, then you have to put the case number. And it'll say, in re the marriage of. And it'll be a list of petitioner, and it will list a respondent. Now, if you are filing a brand new case, you are the petitioner. You are the petitioner. And the other spouse is then known as the respondent. Now, here in Leon County, this is the 2nd Judicial Circuit. There are 6 counties in the 2nd Judicial Circuit. That's important because if you file in Wakulla, you have to go to the Wakulla court in Crawfordville to file your divorce. Now, I'm from Broward County, and that's the 17th Judicial Circuit, and we only have 1 county. I had no idea that it was not like that all over the state of Florida until I relocated to Tallahassee. And so when you are filing anything in Broward County or the 17th Judicial Circuit, it's just 1 county. It's Broward County, but not here. Oh, and 1 clerk. But here, because there are 6 counties, every county has their own clerk's office. There are 67 counties in the state of Florida. There are 67 clerk of courts. But there are not 67 judicial circuits. They are grouped. I know there are at least 20. I can't think any. I'm not sure if it's higher than that, but it's at least 20. Just so you know, it's at least 20. So you want to make sure that you know your judicial circuit. You can Google it, and if not, when you go file the cases, you can ask them, what judicial circuit is this? And they'll tell you. And I'm sure you know your own county. So again, you're filing the case, you're the petitioner. And so now on the form, it says to state I, full legal name. That's you. You filing the case, so that's your name. So if you're Jane Doe, I, Jane Doe, the petitioner. Okay? And it says being sworn, certified, the following statements are true. Number 1 is going to address jurisdiction. Remember I told you they wanted to make sure that you lived here at least 6 months. So it's either you or the respondent or both have lived in the state of Florida for at least 6 months before you file for this petition for dissolution of marriage. Then number 2, they want to know who's in the military. Are you in the military or is your spouse in the military? If not, then check the box. We're not. Because that's interesting now. If somebody's in the military, that's a whole nother ball game because they have some other rules. That's all it is. It's not that you can't get a divorce, but you have to know what the rules are. I'll tell you this. I had a client that was in the military. He was stationed in Japan, but Florida was his home state. And so regardless of where you are when you're in the military, regardless of your geographical location, everyone has what is known as a home state. That's, where you're from for these type purposes. And so Florida was his home state, and we filed for his divorce. The wife had already relocated back to Florida, a totally different county, because he was Broward County and she was in some other county. And we got the court date and the time for the divorce. He had to appear, of course. We had permission for him to appear by phone. It was 2 a.m. in the morning. And so I thought that was kind of interesting. And you have to also have a notary public there to verify that you are who you are. Now that we're in here, I guess we're almost post-pandemic now. With post-pandemic and Microsoft Teams and Zoom, it is wonderful now because the judge will say, sir, ma'am, could you just put your driver's license up near the camera so that I can see it, and they can obtain information that way. Boy, I love technology. Isn't it just wonderful? Okay, so moving right along, as we continue on this form, if there is, number 3, it's marriage history. And they want to know the date of the marriage, and there are some people, especially men, they don't remember the date of their marriage. Ladies, it's a man thing. I don't know what it is, but it is. And the date of separation. Now, it'll say month, day, and year, but most people don't remember, even women, the actual month and the day. So if it's 2016, if you do a year, that's fine. You just leave it blank, really. All right, so place of marriage. And that's the county, state, and the country. Now, I'll tell you what's interesting. There are some people that get a divorce, and they still live in the same house. They still live in the same bed, but they separated for convenience sake. But for all intents and purposes, they truly are separated. And that's fine. It's not a problem. Now, number 4 talks about the dependent or minor children. And this is important. This is so important because when you go to get a divorce, they want to know, when they're children, they want to know if you're pregnant. Now, it may sound crazy, but trust me, because we need to know whose baby that is. Because many people don't realize you could be separated from your husband, but you're still legally married. You're involved in another relationship, and you have a baby from that other relationship. Your husband is the legal father, period. He's the legal father. All right, so you have to then look at the form. Is the petitioner pregnant? When is the baby due? Is the respondent pregnant? You know, that all depends who filed the paperwork. Okay, so if the husband's petitioner, then of course the respondent is pregnant. And then they want to know if there are any children under 18 that are common to both parties. So this part is all self-explanatory. All right, now about the children. Then it talks about a financial affidavit. Are you going to file your financial affidavit with this petition, or is it going to be filed at a later date? So you just check that. And we're going to go over that later. They're children under 18, so that requires a Uniform Child Custody Jurisdiction Enforcement Act affidavit, UCCJEA. That's where the children have lived for the past 5 years and with whom, and if there are any other cases that are going on. Okay, because sometimes there are in other places. And then you have to do an affidavit with your social security number. In our office, we just do the last 4 numbers only. Even if you put your entire social security number on it, that when it goes to the clerk's office, they're going to redact those first 5 numbers. And so, but it's, you know, some of this stuff is public record. And so I strongly urge you to only put your last 4 numbers of your social security. So when you're going to do this form, just put XXX-XX- then the last 4 numbers. And then, of course, the thing that I told you that's required here in the state of Florida, you must make the statement that the marriage is irretrievably broken. You got to check that box, because if you don't, then you can't get a divorce in Florida. It was so funny. Someone contacted me because they couldn't understand why their paperwork was rejected. I reviewed the paperwork and I said, you didn't check the box. Because the other box is that one of the parties has been adjudged mentally incapacitated. And most times we don't ever see those kinds of issues. Saw it once in an annulment at the very beginning of a marriage. But that's a conversation for another story, or a story for another conversation. All right, so now when you're divorcing, most people have obtained some sort of assets or they obtain liabilities. So you can either say there are none, that's easy, or there are assets and liabilities, and they're going to be listed in the financial affidavit, and we need the judge to address it, or we've addressed it, or something. Check the box that applies, and if you don't know which box to check, well, it's okay. It really is. It really is. You'll get a chance to address it later. Now, then the forms talk about spousal support. Now, a lot of people, they check the first one, that they forever give up the right, any right to spousal support, which is alimony. But if you're not, then check the appropriate box. You can put whatever you want to put in it. I have seen people put in here that they want $2,500 a week, and the other person doesn't even make $2,500 a month. But if that's what you want, then you put that in there. You can't get what you don't ask for, so at least you have to ask. And if you change your mind later, that's fine. All right, and so then it goes on to talk about the parenting plan. That's important because, again, you got children under 18, and you have to put in the boxes who the children reside with. Then there are all these things. Should you share parental responsibility? What would you like the time sharing to be like? Time sharing, that's the new word now. Used to be visitation, it used to be custody. Now they say time sharing. And that's important because the number of overnights determine what the child support is going to be. They got a formula for that. Okay, and some guidelines. All right, so in that section, you just put what you like it to be. That's not what it's going to be. It's just your input. Okay, now, so again, child support, there's a section on child support, and you can list that you want child support to be from the time you're filing the paperwork, or from the date of separation, or some other date. You know, don't make it more complicated than it really is, because again, by the time it goes to court, the mediator, the magistrate, and or judge, they will have addressed it. It's just what you want. All right, and so there are some other boxes that talk about insurance, about unreimbursed funds and whatnot. And this is the important thing, ladies, whether or not you want your formal legal name. We say restoration of your maiden name. Now, you can get it done free through your divorce, because if you decide that I don't want to carry his name anymore, then you're going to have to pay for a legal name change. Now, as long as you're not doing this for an ulterior motive, that you're not trying to, file some bankruptcy and change names, or, commit some sort of fraud or whatnot, pretty much they will restore your former name. And so then there's that last thing, which is a request, and that's codifying everything or summarizing everything that you asked the judge for, that you want the judge to do. You want the judge to, address the assets and liabilities if there are any, address alimony if you're asking for it, adopt or establish a parenting plan, and restore the former name, establish child support, and any other relief. That's our little catch-all clause. Well, Mr. Judge, Miss Judge, if I missed anything, then yes, any other relief that the court deems necessary, and the judge will do it. And then you sign it. Now, it's important that you sign it, because it has to be notarized. It has to be notarized, and you need to sign in front of the notary. And so what that does is that takes care of the, what does it take care of? It takes care of the petition for dissolution of marriage. Now, and that's the one with children and with property. If you're doing the one with no children or with no property, then just check those boxes. It's just that simple. And so again, this is Ruby Barr with Southside Community Law Center, making sure that you understand that knowledge is power and power is king.